Hello and warm greetings. Welcome to the Analyst by Vajiram And Ravi, where we would try to comprehensively analyze 7 articles in 2 different sections. In the analysis part, we'll first have a discussion with respect to the importance of workplace health and safety in the context of recurring accidents in different industries. Then, in the second article, we'll have a discussion with respect to the increasing tendency of different states to incorporate anti-conversion laws, more commonly known as Freedom of Religion Acts. Then, in the simplified section, we'll have a discussion with respect to 5 different articles from a special perspective of UPSC Prelims 2025 along with the value addition. So stay tuned. Coming to the very first article of the day, this is workplace health and safety, more commonly known as occupational safety. Now, what we have recently observed is that 6 workers, they have been injured because of a gas cylinder blast in Delhi's Najafgarh. Now, you must remember that just before a few months, we also had a particular incident in Gujarat where 2 workers died after consuming toxic gases. Now, what you need to understand is that in the last 2-3 decades, India has made significant strides in the overall economic activity, be it the construction sector, be it the manufacturing, be it the MSMEs. But there is one aspect of these economic activities where India has not focused, and that is the occupational safety. That is with respect to the workers' safety. So today we will see what this construct of occupational safety is all about, why it is important, what are the issues in the overall structure of occupational safety in India, and what can be the way forward. Now, this is with respect to GSU, issues relating to development and management health. Now, let's first talk about what do we mean by workplace health and safety, also known as the occupational safety. See, basically it's a list of the guidelines, right? It's a list of guidelines and regulations which are basically designed to protect the workers from different hazards. Now, what can be different hazards? For example, it can be toxic chemicals or gases, right, which are used in the manufacturing process, or it can be inefficient machines, obsolete machines, right? Or it can be some of the issues in the construction sector. So these can be the hazards. Now, in order to protect these workers from hazards, we have these guidelines in place. Now, the very objective of these guidelines is to create safe working conditions so that these workers, they can be prevented from injuries, occupational illnesses, and fatalities. Illnesses, for example, we have silicosis, right, which is caused by inhaling silica dust, right? Or it can be serious fatalities. Now, what you need to understand is that it's not just about these injuries. It's also about the overall mental well-being of the workers. So when we are talking about occupational safety, it is a more broad concept, which also includes the physical safety and the mental well-being. Now, what it incorporates is that we need to have proper training with respect to these guidelines. We need to have proper safety protocols in place when we are talking about the working in industry, right? Then compliance with different standards, be it the regulation by the state governments, be it the regulation by the union government. Again, understand that when we talk about labor, it's a concurrent subject, right? So it's a subject which is in the concurrent list. So you can have regulations from both the union as well as the state governments. Now, let's talk about the current status. When we talk about the occupational safety, what you need to understand is that India fares really bad on this part. So we have a report by the International Labour Organization of 2022, which says that on an annual basis, you have around 48,000 people who are killed because of these lack of safety standards, right? So they are basically killed in the course of manufacturing or construction activities. Now, again, as I said, that there are certain specific sectors, be it construction or mining or manufacturing, which are quite high risk sectors. Over there, you have more fatalities. Next is that there are sectoral gaps. That is, there are few sectors where proper adherence to different regulations is taking place. But then there are other sectors, be it the construction sector, be it the manufacturing, especially when we talk about the informal manufacturing, where the compliance is not taking place properly. And because of that, what you see is that there are more number of fatalities. Next is the economic cost. Again, please understand that if a person is suffering from a particular illness, or if a person is suffering from, let's say, a particular injury because of the kind of environment at the workplace, obviously there is a loss to the overall socio-economic capital, right? And obviously that has an overall effect on the whole Indian economy. So that is a kind of effect. Now, also, according to the International Labour Organization, it says that unsafe working conditions in India, it costs India almost 4% of GDP on an annual basis. Now, this is the overall cost. Now, why is having a proper, robust framework with respect to these occupational safety guidelines is necessary for India? The very first is the workers' welfare and rights. See, let's talk about an ethical aspect here. When we are talking about the worker, we need to understand that they should not be treated just as a means. They should be treated as an end. Their overall well-being and safety should be the priority for any employer, right? Next is the global compliance and competitiveness. Now, India has been focusing upon an export-oriented growth where we are trying to increase the exports. Now, what you must remember is that you have certain regions around the world, be it the European markets or be it the Western markets, which definitely give a high importance when we talk about the labor standards, or be it other standards like environment standards. So what we are trying to say is that if India wants to increase its exports to different parts of the world, it has to focus upon robust labor standards so that these countries around the world are in more favor, are more inclined to accept these goods from India. So this is what the importance is. Obviously, it would then increase the overall competitiveness of the industries because workers would be more safe, right? And then they would be more productive. So this is the importance of having these guidelines. Now, what are the issues and challenges in occupational safety? The very first is high informal sector presence. See, what we need to understand is that in India, you have majority of the manufacturing which takes place in the informal part. Now, in this informal part, the first thing is that they do not have the adequate resources to invest in the safety aspect. The employers are not really interested. They're not even inclined to invest in this part. And therefore, what happens is that these workers, sometimes they have to handle these toxic chemicals, or sometimes they have to basically handle these inefficient machines. So therefore, what we are trying to say is that there is a lack of oversight also by different regulatory agencies. So again, all this leads to a kind of a scenario where you see high rates of these accidents taking place, right? So without consistent regulatory oversights and limited safety measures. Next is lack of awareness and training. Because of the lack of resources with these enterprises, what happens is that there is no effective training when we talk about the safety protocols which is given to the workers, right? Workers are not even aware that how to deal with the situation. Let's say if someone has come across in contact with a toxic chemical or a toxic gas, what should be done, right? So they are not even aware with respect to that, and then that leads to poor risk assessment and accident prevention. Then we have inadequate infrastructure and equipment. Most of the industries in India, especially when we talk about the MSMEs, they basically have these obsolete technology, right? They have this outdated machines, and therefore they are more prone to having these accidents. Lack of safety equipment and modern safety technologies. Next is understaffed and underfunded regulatory bodies. Now, when we are talking about this occupational safety, it's not about the lack of investments on the employer part. It's also about having a deficit of personnel when we talk about the regulatory agencies. When we are talking about these agencies which are mandated to see whether the industries are compliant or not with respect to these standards, right? So that what happens ultimately, what happens is that there is lack of effective monitoring, and therefore they're not in a proper position to enforce these standards. Next is fragmented legislation and weak enforcement. The overall picture is that we have a lot of rules and regulation in place, and this aspect of having a comprehensive safety norms, it's missing. So therefore, what it ultimately leads is a confusion, right? Next is weak enforcement. Similarly, as we have lack of personnel involved in maintaining this regulatory oversight, therefore there is weak enforcement from these agencies. Next is that we have sector-specific hazards. Now, there are certain sectors, as I just talked about earlier, which are more prone to having these accidents. Let's take the case of construction. Unfortunately, what we witness is that there have been many cases of falls from the buildings, and these poor people, the vulnerable section, they basically lose their life. Next is electrical mishaps. There have been cases where short circuits have taken place and ultimately it led to fire, and therefore many people died. Then we are talking about the machinery related injuries. So when we are talking about this, what we are trying to say is that these are obsolete technologies. These are obsolete machines. They are having higher chances of malfunctioning. Next is mining activities. Now, in the mines, what happens is that there is sometimes a sudden burst of harmful gases, be it methane, be it carbon monoxide. So that obviously leads to death. Then the risk of mine collapse is there. For example, what you witness in Korba, right? So again, when you have a certain, underground mine which is there, then sometimes it collapses, and then that leads to death of these people. Inadequate emergency measures, be it the usage of these masks. They are not even provided these personal protective equipments, PP kits, right? Or gloves or apron. They're not being provided that. And ultimately, it leads to the death of these people. Then we have got manufacturing. So sometimes, as happened in Gujarat, that there is chemical exposure. Then we have burns. Sometimes the people suffer from burns because of the fire, which happens in a particular manufacturing facility. Then we have got machine-related injuries, same. So again, what we're trying to say is that because of these issues, the kind of risk which is there with respect to these accidents, it's quite high in the country, right? Now, what have been the government laws, schemes and initiatives in this direction? The very first is when we talk about the Occupational Safety, Health and Working Conditions Code of 2020. Now, what this particular code is trying to do is it is trying to amalgamate, trying to basically consolidate almost 13 laws which are related to this safety aspect. The issue with respect to this is, and we'll also study in further articles, that this has not been implemented. There are implementational issues with respect to that, and that is the kind of reason that different enterprises, they are not abiding by these code. Then we have got the Factories Act, one of the very old kind of regulation in the country, which specifically talks about the kind of standards which have to be there in different factories. Then we have got the Mines Act, which is a sector-specific statutory regulation, which basically talks about the standards which are to be there in the mines, so that we can ultimately protect these workers who are working in the mine. Then we have got the Building and Other Construction Workers Act of 1996. Then we have got the Employees State Insurance Act of 1948. It is primarily talking about the social security aspect. Let's say if a particular worker has suffered an accident, suffered injury, so how to deal with the healthcare aspect of that particular person. Let's talk about the schemes. See, we have a particular policy in place, which is an overarching policy which talks about different aspects of health. That is the National Policy on Safety, Health and Environment, which was released in 2009, a very comprehensive policy. Then we have got the Pradhan Mantri Suraksha Bima Yojana. Now this is again a social security initiative which tries to protect the particular worker from these harmful events, also tries to give the pension aspect. Then we have got the skill development programs. Now what you need to understand is that we have the government implementing the Skill India mission. Then we have got the bodies like National Skill Development Corporations, different ITIs. One of the very important aspect in all these bodies is that the government is also focusing upon providing the training with respect to the safety protocols, right? Safety protocols which are to be there in different industries. Next is Employees State Insurance Scheme, again to provide the benefits with respect to the health of these workers. Now, what should be the way forward? The very first is that we need to strengthen the regulatory framework. As I said, that there are so many laws in place. We have already made a code, but there are implementation issues. So we have to simplify them and then strengthen the occupational aspect. We need to make it binding. There has to be a focus upon making these employers follow these guidelines, right? Invest adequately in the safety aspect. Fully implementing this particular code, which and cover both formal and informal sectors. Again, when we look at this picture where almost 90% of these workers are in the informal sector, right, which is obviously not having a proper oversight by the government. So again, there's a need to basically include these workers also so that their lives can be protected. Then we have got enhanced training and awareness program. What should be done is that there has to be adequate focus upon these training programs, safety protocols, right? Different hazards, if exist in a particular industry, they must be identified. Be it the inefficient machinery, be it the toxic gases or chemicals, they must be identified and rectified. Then emergency preparedness should be one of the very important aspects. There has to be frequent drills, events, so that the workers can be made to realize the importance of the emergency preparedness. Next is increased safety inspections and monitoring. What we need to basically focus upon is hiring and training more safety inspectors. The aspect of the deficit in the personnel with respect to these regulatory agencies. We need to have a robust regulatory setup so that these agencies are in a condition to have a proper oversight on these workers. There can be so that they can conduct surprise checks, visits, inspections, right? Especially in the high-risk sectors. Then there is a need to focus upon technology, very important aspect. See, what we're trying to say is that integrate technology with the manufacturing process. Let's say artificial intelligence or machine learning, right? And adequate incentives can be provided by the government to these even small players in the market. Now, what it would do is that once you would have these technologies in place, AI and machine learning, or let's say automation, right? So that would definitely give a sort of a database analysis to these employers so that they can basically realize that these are the risks involved, right? And then they can work upon that. Also, for those machines which are quite risky, which involves high temperatures, over there what we can do is we can basically remove the manual intervention part by automation. So automation can be done, automation for high risk areas. Next is promote incentives for safety compliance. For those enterprises who are really abiding by the rules, there has to be some kind of incentives, be it some kind of tax incentives. On the other hand, those enterprises who are not abiding, they should be penalized, right? Next is extend social security and insurance coverage. What we are saying is government is already coming up with these schemes like Pradhan Mantri Suraksha Bima Yojana. But again, we need to increase the number of people who are participating in these schemes so that the pool of the people who are receiving the benefits out of these schemes increases, right? Next is we have to focus upon international collaboration. Let's take the case of International Labour Organization. What we can have is we can seek some kind of technical assistance, some kinds of a sort of a mechanism where there's adequate consultation with these bodies so that they can provide us the expertise, right? Again, what we are trying to say is that there have to be consistent interactions between these international organizations so that we can have more effective training programs, and then we can also develop guidelines regarding same. So what we are trying to say is, again, that we have focused a lot upon increasing the economic activity, but we have not focused upon this aspect of maintaining the worker safety, enhancing the worker safety. So that should also be considered. Again, look at the ethical aspect. That is, workers should not be treated as a means. They should be treated as an end. Next aspect is that we should focus upon this aspect because that would increase the overall social and economic productivity of the country. So these are the steps which must be incorporated so as to promote an environment, a workplace environment which is more secure, which is more safe for these workers. That is what you need to know with respect to this article. Let's look at a particular mains practice question. The question says, discuss the current status of the workplace health and safety in India, highlighting the key issues and challenges faced by the workers across various sectors, analyze the effectiveness of existing government laws, policies, and initiatives aimed at ensuring the worker safety and well-being, suggest a comprehensive way forward to strengthen the occupational safety standards in the country. 15 marks, 250 words. Please do write a particular answer on this question. So coming to the next article, this is with respect to the Freedom of Religion Act, more commonly known as anti-conversion laws. So we have the Chief Minister of Arunachal Pradesh, Mr. Pema Khandu, who has said that now the state is going to come up with the rules with respect to the Freedom of Religion Act, which basically prohibits the religious conversions by the use of force, inducement, or fraudulent means. Now, what you need to understand is that this law was made in the year 1978, but since then it has remained dormant because rules were not made. Now the rules would be made and then it would be finally implemented. What you need to understand, the overall picture is that there has been an increasing tendency by different states to come up with these anti-conversion laws. Some people say that these laws, they basically violate the fundamental rights. Some people say that they are actually necessary. We look at the both aspects, right? This is a part of GS2, fundamental rights. Now, let's first talk about what are these anti-conversion laws, more commonly known as the Freedom of Religion Act. See, these are the legislative measures, the laws, which basically aim to prevent, to curb or prohibit these religious conversions. Not all religious conversions, but specific type of religious conversion. Now, again, understand. Let's say you have a person who is trying to convert to a particular religion out of his spiritual awakening, spiritual inclination to that particular religion. It is perfectly fine. But let's say the person is converting to a religion because of lure of money, because of fraudulent means. If the conversion is, let's say, forced, so that is something obviously which has to be curbed. And again, the very objective, what these different state governments say is that we are actually having these laws in place so as to curb these kind of conversions. Now, they aim to prevent forced or induced conversions. Let's talk about the history of these conversions, these laws. Now, they were basically also introduced in the times of the princely states in the 1930s and 40s. And the very objective of these regulations was to basically curb the conversions which were taking place because of these Christian missionaries. Example include the Raigad State Conversion Act of 1936, the Patna Freedom of Religion Act of 1942. Then we had different bills in the parliament which were put forward, but again, they could not be passed because of the lack of parliamentary support. Now, in 2015, it was very clearly said by the Law Ministry, very clearly said, that this matter is a purely state subject. That is, the parliament has no authority with respect to coming up with a law when it deals with these anti-conversion laws, right? It is only the state government which can go with this. Such a law made by the parliament would not be in accordance with the tenets of the constitution. This means that these conversion laws are completely in the domain of states. Now, as I said, that we had the particular law ministry which said in 2015 that the parliament cannot make a law. Now, let's talk about the bigger picture, that how these anti-conversion laws, they violate the right. See, the very first is Article 25, which talks about the freedom of conscience and to freely profess, propagate, and practice religion. Now, we have this fundamental right. Now, let's say if a person wants to convert to a particular religion, that person should ideally be allowed to convert. There should not be an state interference with respect to that. That is how some people say that it violates Article 25. Next is we have Article 19, subclause 1, subclause A, freedom of speech and expression. If a person is engaging himself or herself in a religious discourse, that is with respect to the conversion of religion. But if the state interferes in that aspect, so that is also an infringement of freedom of speech and expression. Next is right to privacy. We had a very famous case in 2017, case Puttaswamy, where the Supreme Court very clearly said that right to privacy is a very integral part of Article 21, right to life and personal liberty. Now you need to tell me the case in which the domain of Article 21, right to life and personal liberty, was broadened by the Supreme Court. What was that case where due process was introduced? Now, privacy is something which is an integral part with respect to a person, and religious is also a part of person's private affairs. So if the state is interfering in this aspect, that is probably a violation of right to privacy. Next is Article 14. What different critics say that these laws, these anti-conversion laws, they are targeting particular communities. They are especially targeting the minorities. That is what they say. And therefore, they violate the equality before law and equal protection of law, which is given in Article 14. Next is right to dignity. Religion is something which is obviously an integral part of the dignity of a person also. So if the state is interfering in that aspect, it is basically violating the dignity. Next is, as I said, that there has been an allegation that it is leading to the suppression of different minorities. Now, what you need to understand is that it was the famous S. Pushpabai case where the Supreme Court very clearly said that we don't have any problem with the conversion. But the conversion should basically fulfill two conditions. First is that the conversion should be voluntary, out of one's own will. Second, the conversion should be sincere. That is, it should not be something which is out of lure of money or fraudulent means, right? There has to be a proper spiritual awakening of that person. If a person wants to convert from religion A to B, he must see that aspect in religion B. He must have that kind of spiritual attraction towards the religion B. It should not be based on the lure of money. Then, why is there a need of conversion, anti-conversion laws in the country? See, again, to basically restrict these type of conversions, which are based on these motives, on the lure of money, fraudulent means, we have these anti-conversion laws. The very first is, it prevents coercion and fraud. Now, if you look at the statistics, what you would see is that these majority of the persons who are being converted, they belong to the low socioeconomic backgrounds, right? Again, there has been a sort of a forced conversion. People are being forced to convert. There are some agencies, entities who are involved in that. So again, on the basis of these laws, with the help of these laws, we can restrict the coercion and fraud. Next is preserving social harmony. When you have such kind of conversions frequently taking place in the society, it obviously leads to a kind of mistrust among the people, right? And then that can lead to more conflicts in the society, which is obviously not good for any nation. Next is protecting the cultural identity. See, please understand, a religion which is being professed by a particular person, that is a very integral part of that person's culture. Let's say you have a group of people. Now, they were initially having from religion A. Now they are being converted to religion B. Obviously, what it means is that their culture would also be sacrificed. And that would lead to the erosion of these cultural values. Next is address national security concerns. Yes, there have been reports by different intelligence agencies that there are a lot of non-state actors, not just from India, but also from other countries, who are funding these activities and trying to basically promote these anti-social activities, which obviously destabilizes the country. Next, let's talk about what has been the Supreme Court's view. See, we had the very famous case of Reverend Stanislaus versus State of Madhya Pradesh of 1977. In this particular case, the Supreme Court very clearly upheld the constitutionality of these anti-conversion laws of the state of Madhya Pradesh and Odisha, right? Said that yes, they are constitutional. Next is we have the famous case of Hadia versus Ashokan KM. In this particular case, the Supreme Court said that a person is free to marry a person of his or her own choice, right? And then that person can also convert to any religion. Then we have got the famous case of K.S. Puttaswamy. In this case, as we all know, that the right to privacy was declared as an integral part of Article 21. And again, the converting to a particular religion is also part of one's private affairs. Then we have the case of Lata Singh versus State of Uttar Pradesh. Now, in this particular case, the Supreme Court said that there is a need of stringent punishment when we talk about the cases of violence in the intercaste or interfaith marriages, right? There's a need of stringent punishment. Next, we have the Sarla Mudgal versus Union of India, very important case. In this case, the Supreme Court basically said two things. Let's say a person is converting from religion A to religion B, but that does not mean that the person can run away from his legal or moral responsibilities. That is one thing. Second is what the court said, that if a person is converting to Islam just for the sake of marrying more than one time, that is polygamy. So obviously this cannot be allowed. So that is what the Supreme Court said in Sarla Mudgal case. Now, what should be the way forward? See, what we are trying to say is obviously the state cannot interfere when we talk about the individual's right to convert. If the conversion is pure, if the conversion is out of spiritual awakening, inclination to a particular belief, then definitely that conversion should not be stopped. But if the conversion is based on malified intentions, is based on lure of money, inducements, right, or if it is forced, then that should not be allowed. That is the one aspect. Second is, what should be the way forward? That whenever the state is making a law with respect to these conversions, it has to have a sort of a stakeholder approach. It has to include the theologians of different religion or community, the members of different community, so that it can have a more consensual based approach, right? It should not be a forced approach on the part of the state. So that is what you need to understand. This particular topic can be really important, considering that a lot of states are actually have come up with these laws. So this is what you need to know with respect to this particular article. Let's have a mains practice question. The question says, the subject matter of anti-conversion laws by different states in India is fraught with various debates. Elaborate. 15 marks, 250 words. Do write a particular answer in this question. So coming to the simplified section, we have the first article as the 4 labor codes. See, let's first talk about the gist. So the picture is that we have the subject of labor as a part of the concurrent list, where both the center as well as the state can make a law with respect to the labor. And because of that, you had numerous labor laws in place. And then that led to confusion. In order to basically restrict or end this confusion, we had the government of India, which basically came up with these 4 labor codes, already been passed by the parliament. But what you need to understand is that still you have many states who have not basically formed the rules or regulations with respect to these labor codes. And because of that, the implementation is missing. That is what we discussed even in the first article. So now what the Labor Ministry has said is that now we are going to implement it very soon by next year, right? Now we are trying to basically focus upon the harmonization of these rules by different states. Again, what you need to understand is that we have a very important article, Article 254, which talks about that whenever there is inconsistency between a sort of a parliamentary law on a concurrent list subject and a state law on the same subject, then it is the will of the parliament which prevails, right? So that you need to understand. And because of that, the Union Labour Ministry is trying to make sure that there is harmonization with respect to the rules and regulation which are formed by different states when we talk about the labor issues. That is the whole gist. So as of now, the 4 labor codes have not been fully implemented in India, although they have been passed by the parliament and received the presidential assent. These codes aim to consolidate and simplify the existing numerous labor laws into 4 comprehensive labor codes. So we have the code on wages, we have the industrial relations code, we have the code on social security, we have the occupational safety, health and working conditions code. These are the 4 labor codes. The government has framed the rules for these codes, but their implementation is pending because several states are yet to finalize these rules, respective rules, as labor is a concurrent list subject. Now what these different 4 labor codes talk about? So we have the code on wages. It deals with the minimum wages, timely payment of wages. Then we've got the Industrial Relations Code, talks about the industrial disputes, trade unions. Then we've got Social Security, talks about the social security benefits, including to the gig and platform workers. Then we have occupational safety, we just talked about, focuses upon the workplace safety, health and welfare measures for these workers. Now, next aspect is what are the reasons for delay? Now, this is not mentioned in the article. The very first is pending rules from the state. What it is trying to say is that many states, they have even not drafted these rules and they have failed to notify these rules. Therefore, the implementation has not taken place. Then there are concerns with respect to stakeholders. What many stakeholders feel that they have not been consulted, be it the employers, the workers, they have raised concerns. Next is economic and political factors. Many of the commentators have said that once these labor codes would be implemented, it might lead to a sort of economic downturn because of the restrictions imposed on these employers. And also, especially after the recovery, we were actually aiming for during the post-COVID times. Now, The article says all the 36 states and union territories are expected to complete the harmonization and pre-publication of these draft rules by 31st March 2025. So far, barring 5 states and union territories, all others have pre-published the rules, setting the stage for the much-awaited rollout of these 4 codes, which we have already talked about. The Labour Ministry has been consistently working for the harmonization of these rules under the 4 codes across different states. Now, again, as we talked about, Labour falls under the concurrent list of the Constitution. Hence, both state and the centre are empowered to make rules. But now this is where we have Article 254. But in the event of a conflict between the state and the central laws, the central legislation generally takes precedence unless the state law has obtained the presidential assent. The 4 labour codes are judicious combination of reforms aimed at easing the labour market rigidities, that is the complexities which are there in the overall labour market, and reinforcing the workers' right and welfare. As many as 44 labour-related acts were consolidated into the 4 codes in 2019-20. With the objective of reinforcing trade and investment, facilitating the ease of doing business, and easing the compliance. Several minor offences were decriminalised via the codes, while skill development and dispute resolution have been accorded priority. Meanwhile, the ministry is also working towards development of a framework for social security coverage to gig and platform workers. We've already discussed this in one of the previous analysts where we talked about the gig economy. Next is extensive stakeholder consultations were conducted with the aggregators, knowledge partners, platform workers, states and union territories this year to ensure a comprehensive understanding of the Social Security Code. Now, please understand, this is what the notification by the Labour Ministry is saying, right? But on the other hand, you also have different stakeholders like the employers, the unions, labour unions, who are saying that adequate consultation has not been done. Next is to develop collaborative approach for social security framework and tailored to gig and platform workers. Also, collaborative studies being undertaken with different organizations, for example, International Labour Organization, to comprehensively assess the various factors related to platform workers. These include the number of platform workers, prevalent business models, potential schemes, financial implications, and a roadmap for implementing a social security scheme for platform workers. Again, the overall gist is that they have not been implemented so far because many states, they have failed to basically draft and notify these rules. But now what the Labour Ministry is saying that we are going to do it by 31st March 2025. So let's see what happens next. This is what you need to know with respect to this particular article. Now coming to the next article, this is with respect to a directive given by the National Green Tribunal to the Uttar Pradesh government and Central Pollution Control Board, saying that these bodies should make sure that the water in the rivers of Ganga and Yamuna is fit for drinking and bathing during the Mahakumbh Mela. So now why this article becomes important is that it has a mention of 2 very important bodies. First is the National Green Tribunal and the second is CPCB. Now that can be really important once we are talking about your prelims exam. So we'll have a comprehensive look with respect to the functions and the role played by these bodies. So what the article says, the National Green Tribunal Principal Bench has ordered the UP government and the CPCB to ensure that no untreated sewage is discharged into Ganga and the Yamuna during the Mahakumbh Mela of 2025 so that no pilgrim suffers. This comes as generation of sewage is estimated to increase by 10% during the event in Prayagraj. The tribunal also said that the authorities have to make sure that the river water is of drinking water, bathing water quality at all times. The Mahakumbh Mela will begin in Prayagraj on January 13th and end on February 26th. The order said that the CPCB and the Uttar Pradesh Pollution Control Board have to collect the water samples from the Ganga and the Yamuna rivers at least twice a week from the monitoring points and display the analysis report on their website. Now, let's talk about the very important body, the Central Pollution Control Board. How was it established? Now, this was established in 1974 under the Water Prevention and Control of Pollution Act of 1974, right? Now, what are the governing legislation? What you need to understand is that it not only basically enforces the provision of the Water Act, but it also has a power to enforce the provisions of the Air Act, that is Air Prevention and Control Pollution Act of 1981. Now, it acts as a statutory organization under the Ministry of Environment, Forest and Climate Change, advises the central government on the pollution-related matters, coordinates the activities of the state pollution control boards, monitors the pollution level, be it the air, water and soil across India, develops and enforces the environmental standards such as effluent and emission norms, effluent from different industries, right, and emissions from different industries, conducts the environmental research and provides the technical assistance. Next, it also manages the National Air Quality Index. What have been the key initiatives? We have the National Ambient Air Quality Monitoring Program. Then we have got the National Clean Air Program. Then we got the effluent monitoring for industries discharging into the rivers and water bodies. What are the challenges? The very first is inadequate infrastructure for real-time monitoring. Please understand, the overall jurisdiction of CPCB is for whole of the territory of India. Now, this obviously, it's a kind of a stumbling block for the organization because it doesn't have that much of resources, but still it is trying to focus upon these aspects. Limited enforcement capacity against the violations, coordination issues with the state pollution control boards. Now, let's talk about the National Green Tribunal. So now NGT also has a statutory basis, was formed on the basis of National Green Tribunal Act of 2010, provide a specialized judicial body for the expeditious disposal of cases related to the environmental protection and conservation. Very specific, that is related to the environment protection and conservation. Headquarters in New Delhi, but it has a lot of regional benches in Bhopal, Pune, Kolkata and Chennai. Now, what cases it handles with respect to the environmental protection, conservation of forests, enforcement of any legal right related to the environment, issues of concerning the pollution and biodiversity. Then different acts have been there with respect to which this takes a decision. We have the Water Act, Air Act, Environment Protection Act, Forest Act of 1980. Now, it also adjudicates the cases on the principle of sustainable development and polluter pays. Now, this principle of polluter pays, this is a very significant pillar when we talk about environmental management aspect. Now, can you tell me two rules in the country which are based on the polluter pays principle? Provides relief, compensation and restitution of damaged property or the environment. Now, what are the powers with respect to the NGT? Now, NGT is not bound by the Civil Procedure Code, but follows the principles of natural justice. Now, why this becomes important is that many times a statement directly having such kind of lines have been put in the prelims. So, please do pay attention. Has a power equivalent to a civil code. Decisions are binding and can only be challenged in the Supreme Court. Achievements, it has played a very important role once we talk about the banning of illegal sand mining. Direct actions have been there with respect to the improvement of air quality in the Delhi NCR region. Impose penalties on different industries for the non-compliance of pollution norms. What are the challenges? Again, first is that it does not have enough financial and infrastructure resources. That is obviously a constraint. Next is backlog of cases due to increasing caseload. More and more number of petitions have been filed in the NGT, and that is obviously leading to more pendency. Limited jurisdiction in some environmental matters. So again, these are the issues, but still, these bodies have really helped to maintain the environmental standards in the country and make sure that we have less pollution and people are more inclined to sustainable living. So that is what you need to know with respect to this particular article. Now, coming to the next article, this is with respect to the National Maritime Heritage Complex. The gist of the article is that we have a very important place in Gujarat, that is Lothal. Now, Lothal, it has its own historical significance and it dates back to the Indus Valley civilization. Why it is famous is because it had a sort of a very advanced dockyard and it also served as a very important point of trade. Now, therefore, in order to basically recognize this historical legacy, maritime history, maritime legacy, we have the government which is focusing upon the construction of National Maritime Heritage Complex at Lothal, and the different ministers are basically reviewing the progress of this particular project. This particular complex can be really important once we are talking about your prelims exam. So let's study this. So Union Minister of Port, Shipping and Waterways, then we have the Minister of Labour and Employment and Youth Affairs and Gujarat Chief Minister. They held a joint review meeting to assess the progress of National Maritime Heritage Complex. Now, under the Sagarmala program, the Ministry of Port, Shipping and Waterways is developing the NMHC at Lothal in Gujarat. This particular world-class facility will showcase India's maritime heritage from ancient to modern times, adopting edutainment approach, that is education and entertainment. Please see, this can be really important for your prelims exam. Have a look at this. Lothal, a prominent city of the Indus Valley civilization dating back to 2400 BC, holds historical significance for its advanced dockyard, thriving trade and renowned bead-making industries. Artifacts such as seals, tools, pottery unearthed by the archaeologists reveal a rich cultural and economic history, making it a pivotal site of the Harappan civilization. Look at this. There are certain important sites with respect to Indus Valley. We have got Lothal, we have got Rakhigadi, we have got Kalimangan, we have got Harappa, we have got Mohenjo-daro, right? So just have a look at this particular map, can be important. Now, the minister has said that the National Maritime Heritage Complex project will boost tourism, provide platform for maritime education, foster collaboration between India's maritime community and global industry. He further said that it will create employment, foster skill development and empower the youth of Gujarat. The NMHC is poised to become the cornerstone of India's maritime legacy, harmonizing cultural and historical significance with economic and educational development. You can have a look at this particular picture. It shows how different activities they took place in Lothal during the Indus Valley civilization. That is what you need to know with respect to this particular article. Now, coming to the next article, this is with respect to the National Commission for Women. Now, in this particular article, what it says is that the NCW has taken a suo motu cognizance with respect to a particular case of sexual assault in the Anna University. Now, therefore, this particular body really becomes important for us. So, we'll see what the origin of the body is, what are the functions, and what are the issues. So, the article says that after taking a suo motu cognizance of the sexual assault on a student on the Anna University campus and issuing a notice to the Tamil Nadu police seeking an explanation on the steps taken in the arrest of the accused in the case, the NCW, National Commission for Women, on Saturday constituted a fact-finding committee to probe the incident. Now, this is something which is important. That is, it tells us about the powers of NCW. Now, the National Commission for Women was established on January 31st, 1992. The statutory basis is the National Commission for Women Act 1990. This is the law. To safeguard, the objective is to safeguard and promote the rights and interests of women in India. Composition appointed. You have a chairperson who is appointed by the central government, which is a person of eminence committed to women cause. Members, 5 members, including a member secretary. At least one has to be from scheduled castes or scheduled tribes. What are the functions? First is policy advice. That is, it advises the government on the women-related policies and legislative aspects. Legal aid. Reviews the constitutional and legal safeguards for women, recommends amendments to the laws that discriminate against women, inquiry and investigation. So it investigates complaints of violation of women's rights, takes suo motu cognizance of the incident of gender-based violence or discrimination, as it has done in this particular case. It can also take up suo motu investigations. Then, awareness and research. Promotes research, publications and awareness campaigns for gender equality. Coordination, works with different state governments so as to ensure a uniform response to gender issues. Special studies, conducts studies on gender-related issues such as trafficking, workplace harassment and health. Now, what have been the achievements of the NCW? Now, this NCW has been really a very important body with respect to the formation or enactment of certain laws. For example, the Protection of Women from Domestic Violence Act of 2005, amendments to the criminal law related to sexual harassment and rape. It has advocated for women reservation in Parliament and state legislature, played a pivotal role in spreading the awareness about women's rights. Next, what are the challenges? First is, understand. Though it's a quasi-judicial body, the kind of advices, they're not binding on the government. So that is something which is a very important issue. Acts only as a recommendatory body with no enforcement authority. Resource constraint, obviously. Faces challenges due to the inadequate funding and staffing. Overlapping jurisdiction, that is, lack of clarity in coordination with state-level women commissions. So sometimes what you see is that there are debates and sort of contradictions between the state women commissions and the National Commission for Women, right? Now, what should be the way forward? First is empower the NCW with judicial and punitive authority so that its decision can be more binding in nature. Increase the budgetary allocation and infrastructure support. Promote stronger collaboration with state and local bodies to address grassroots issues. Now, what we are trying to say is that when you have the NCW and different state commissions for women, there has to be a smooth cooperation, coordination and collaboration among these bodies so that effectively we solve the issue and ultimately we have a more gender equal society. So this is what you need to know with respect to the NCW. So coming to the last article of the day, this is with respect to the Davos Summit of the World Economic Forum, which would be held in February next year. Now, why this article becomes important is that we have a lot of ministers who are going to participate from India to this particular summit, and obviously a question in the prelims can also be formed. So what the article says is that the Union Ministers Ashwani Vaishnav, C.R. Patil, Chirag Paswan, K. Ramohan Naidu, Jayant Chaudhary, along with the Chief Ministers Devendra Fadnavis and Chandrababu Naidu, A. Revanth Reddy, will join the hundreds of government and business leaders from across the globe in the Swiss Sky resort town of Davos for the World Economic Forum's annual meeting in February. Over 50 presidents and prime ministers from across the world and top officials of international organizations such as the United Nations, IMF, International Monetary Fund, World Bank, Interpol, NATO, North Atlantic Treaty Organization, European Central Bank, and the World Trade Organizations are also expected to be in Davos for the World Economic Forum's annual meeting. The theme of next year is going to be collaboration for the intelligent age. Do remember, there can be a probable question which says that which of the following bodies has this particular theme, right? Now, let's talk about this particular summit. Important, can be asked in prelims. The World Economic Forum annual meeting, commonly known as the Davos Summit, is a high-profile event where global leaders from politics, business, academia, civil society gather. So one thing is very clear, that it's not just about the politicians coming here. You have people from different backgrounds, business, academics, politics, right? To discuss pressing global issues and collaborate on solutions. What are the key details? The first is that it is organized by the World Economic Forum. Now, this is a Switzerland-based non-profit organization which was founded in 1971 by Klaus Schwab. Location, it is held annually at Davos, a mountain resort in the Swiss Alps. Typically takes place in January every year, although it has occasionally been rescheduled. Participants, as I said, that it involves the head of the governments of the state, CEOs of major corporations, leaders of international organizations, academics and thought leaders, representatives of civil society, media, and cultural sectors. Theme, every year it has different themes. For example, this year is in the year 2025, it's going to have the collaboration for an intelligent age, right? Now, what is the importance? It is a very important platform once we talk about the global dialogue on different sort of topics, right? Provides a platform for discussing and shaping global, regional, and industry agendas, economic cooperation. Again, it basically tries to enhance the partnership among different stakeholders between the government, private sector entities, international organizations. Innovation and sustainability. It basically talks about the emerging technologies. For example, in the year 2025, the theme is with respect to the intelligent technologies, right? Emerging technologies and solutions for the issues like climate change, inequality, economic recovery. Then it also focuses upon some of the global goals. For example, the Sustainable Development Goals. What is the criticism? The very first is that the forum has been criticized for being elitist, right? That is, it's often criticized for being exclusive and catering primarily to the global elite. Next, lack of actionable outcomes. Though we have a lot of discussions taking place in the WEF forum, but again, though they do not have something substantial on the ground. While it generates ideas and discussions, critics argue it lacks tangible and forcible commitments. So this is what you need to know with respect to this particular article. Probably a question in the prelims can come with respect to this particular summit. So that is it for today. I hope you really enjoyed the session. Do let us know through your likes and comments. Thank you. All the best.